Good morning, Your Honor. Michael Bavana on behalf of Jillian Carey, present to my right.
Your name, ma'am?
Jillian Carey.
All right.
Before we even hear the first words spoken in this courtroom, it's important to understand what kind of hearing this is and why the tension is already thick. This is not a trial. This is not a verdict day. This is a procedural chess match where timing, discovery, and leverage matter just as much as facts. What you're about to watch is a defendant caught between two domestic violence cases, unresolved discovery disputes, and a judge who has very little patience for gamesmanship. Judge Simpson sets the tone early in these proceedings. Direct, blunt, and unwilling to tolerate confusion dressed up as legal maneuvering. At the center of this case is Jillian Cry, a defendant whose legal situation is already complicated before the court even addresses bond conditions or preliminary examination dates. The attorneys are walking in knowing discovery issues are unresolved, and that alone puts this hearing on a knife's edge. When discovery isn't complete, everything slows down. But when one side claims it's being denied materials and the other insists everything has been turned over, that's when sparks fly. Pay close attention to how quickly this shifts from scheduling logistics into a power struggle. The judge isn't interested in hypotheticals or future reports. He wants clarity, accountability, and answers now. This opening sets up the entire hearing: frustration, legal brinkmanship, and a defendant whose freedom depends on how carefully everyone chooses their next words.
What are we doing on this?
Your Honor, we're going to be studying this for a preliminary examination.
I think we were looking and speaking with Mr. We're still hopeful that there may be an additional report from Detective Parvez, but we're fine with setting this if we could set this into January if possible.
You would agree with that, counsel?
Yes, Your Honor, the weeks of January 20th, particularly.
Well, you don't get to pick a week.
Or the 13th.
And all discovery is complete, is that correct, counsel?
Other than perhaps that report, yes.
With the exception of the materials that I requested and was denied, yes.
I don't know what that means.
Your Honor, you denied a motion to compel discovery last time. That is the material I'm talking about that I've not received and the court has not examined. So that will be the discovery that I'm talking about. But I'll pursue that at a different level. Your Honor has already denied my motion, so.
This exchange is a textbook example of how discovery disputes can derail a case before it even reaches a preliminary exam. The defense attorney is essentially saying, yes, I have what the prosecution gave me, but I don't agree that it's everything I'm entitled to. That distinction matters. Discovery isn't about what the prosecution feels like handing over. It's about what the law requires them to disclose. However, Judge Simpson makes something very clear here. Once a motion to compel is denied, the court has already ruled on that entitlement. What's happening beneath the surface is a clash between procedural rights and judicial authority. The defense is preserving the issue for appeal by openly disagreeing with the court's ruling, but Judge Simpson is not going to let that disagreement stall the entire case indefinitely. From his perspective, refusing to acknowledge discovery as complete while simultaneously having all court-approved materials is a contradiction.
I still don't know what that means. Do you have all of the discovery, counsel?
I have all the discovery that they've given me, yes.
And if I denied your motion, that would mean that would be something that you're not entitled.
That's the court's position. I don't agree with the court's position, and so I can't answer that question that I've gotten all the discovery.
All right, then I'm not setting it for exam until we're sure that discovery is complete. That's how we work here,
okay.
Counsel. So you guys figure it out. From the people's perspective, has discovery been completed other than the one thing you've indicated?
All right. Well, since we were last here in court, Detective Parvez did offer what I would call a supplemental report that has been tendered via email about 2 weeks ago. I also discovered there had been some body cams that hadn't been properly notified, like notice had been sent to my office. Those have also been tendered. So as far as from what is in possession of the people, everything has been turned over. The only remaining discovery that may exist that I'm aware of would be this additional supplemental report by the detective, but that investigation is ongoing.
So I'm going to try this again, counsel. You have all of that. You may disagree with this court's decision, and I could care less, quite frankly. If you want to appeal it, appeal it.
This is Judge Simpson at his most unfiltered, and it's deliberate. When a judge says, "I could care less if you disagree," what he's really saying is that the courtroom is not the place for posturing. Appeals happen upstairs, not here. Right now, his only concern is whether the procedural boxes have been checked so the case can legally move forward. Notice how he reframes the issue. He doesn't ask whether the defense is happy. He asks whether the defense has received everything the prosecution described. That's a critical distinction. Judges care about objective facts, not subjective dissatisfaction. By forcing the defense to answer that specific question, Judge Simpson shuts down ambiguity. This moment also shows judicial efficiency in action. Courts are overloaded. Judges are under constant pressure to move cases along. When attorneys attempt to slow proceedings with unresolved disputes that have already been ruled on, judges tend to respond sharply, and that's exactly what we're seeing here.
The question is, in terms of what should be supplied to you, do you have everything?
I have everything that was described by the prosecutor, Your Honor. So yes.
The people would have their witnesses available January 21st, 2025.
I don't see any reason why not.
Preliminary examination in person, January 21st, is it?
Yeah.
2025, 9 a.m. That's before me. And counsel, if you want to keep playing these wordsmith games, I'll go toe to toe.
Your Honor, I'm just,
Thank you. Bond will continue. We're done.
okay.
If you want to address it, Commissioner Vaughn?
Oh, I'm sorry. There's one more matter, Judge, to address. My client is currently restricted to travel in the state of Michigan. Her family is located in Toledo, Ohio. I would ask if she'd be allowed to travel over the holidays.
Prepare an order, get it to the court today. I'll sign off on it.
Thank you, Judge.
Thank you.
Assistant Public Defender, Samantha Carey. I can really, on behalf of Ms. Patsy Shear, please approach it. Shear, could you state your address for the record? Patsy Shear. Your Honor, there are two matters, and we would like to adjourn to look into a global resolution. There's a district court matter as well as the
Which district court?
1484.
Okay. So why are you telling me that?
We're adjourning for global resolution, Your Honor. Continue.
But I don't have that
negotiation.
other one.
You don't.
I only have the felony.
That is correct.
So why are you telling me about it?
So, given the reason for the adjournment, we are.
No, I'll
Same
wait.
thing.
This is gonna be a long explanation.
That further negotiations is our reason for the request for adjournment.
I know, I see that on the form. So, all right. Chinaza.
Yes, sir.
All right. So when do you want this adjourned? So the other one is set.
Correct.
The other case is 1484.
You could have stepped in earlier.
Violence case. It is set for December 5th.
Got it. So you need this before or after December 5th?
After is fine.
After the 5th. See, it would have been that easy. But
We said the same thing.
I don't know what.
This exchange highlights something that often goes unnoticed by the public. How much courtroom friction comes from poor communication, not legal disagreement. The judge's frustration here isn't about the adjournment itself. It's about how unnecessarily complicated the explanation became. When Judge Simpson says, "It would have been that easy," he's pointing out that lawyers sometimes bury simple requests under layers of procedural noise. Adjournments are common. What irritates judges is when attorneys fail to lead with the actual reason. In this case, the presence of another pending district court matter was the real issue, but it took far too long to surface. That delay wastes time, and judges guard their calendars fiercely. There's also a subtle lesson here about credibility. When attorneys appear disorganized or indirect, it affects how judges perceive their future arguments. Even valid requests can lose weight if they're poorly presented. Judge Simpson's response reinforces an expectation. Clarity first, explanation second.
How you were leading with whatever you were doing. But
We said the same thing.
what?
What she said, we said the same.
No, you didn't. You really didn't. December 12th, 2024, 9 a.m. Bond will continue.
One aspect.
Oh.
Defendant this year was arraigned She was not equipped with a GPS tether despite the fact that we requested one. I am concerned that this case, that we have now 2 domestic violence cases and there is no GPS tether. I do know that there is a no contact order, as well. I would be requesting a GPS tether.
And Your Honor,
Go ahead.
the people did, Ms. Poisson did indicate that that would be their request today. When I spoke with my client, she indicated to me that that request was made at the arraignment. However, after arguments from both attorneys, the magistrate who arraigned her at the time indicated or decided that there was no reason for a GPS tether. There is a no contact in order. My case, or at least this case, was of January 2024. So she was arraigned, I think, subsequently on both of the cases when the new 14A4 matter occurred. So
Well, when was the 14A4 matter? When did that one arise?
that it was Monday.
Monday, so it's sorry.
Of
Just
November 18th. This is January. So, and they were arraigned at the same time.
correct. I think the January instance, she was taken to the hospital, Your Honor, and then released, but she did not know that there was a warrant that had issued from that.
And that's this case.
That's our case, correct? Yes.
But I think the thing that I'm concerned about, Your Honor, is that we now have 2 domestic violence cases with this
I got-
same victim.
This is where the case shifts from procedural to personal safety. Once the court acknowledges the existence of 2 domestic violence cases involving the same alleged victim, the legal calculus changes entirely. Bond conditions are no longer about convenience. They're about risk management. GPS tethers are not punitive by default. They're preventative. And Judge Simpson's concern is rooted in escalation, not history alone. The defense points out that a magistrate previously declined to impose GPS monitoring, which is a valid argument, but it's not dispositive. Judges are allowed to reassess bond conditions when circumstances change. A second case is exactly the kind of change that triggers heightened scrutiny. Judge Simpson's questioning about addresses is especially important. Confusion over where the defendant lives raises red flags. Courts rely on stable, verifiable residence information to enforce no-contact orders. When that stability disappears, monitoring becomes more likely.
And so even if the magistrate didn't believe that a GPS tether necessarily was appropriate in a case dating from January, with the addition of a new case, I think that it's necessary at this point.
Well, what was the rationale? You're saying it was addressed, but
Yes.
the magistrate's rationale in that I'm a bit perplexed by. Who's residing at the Valley Circle address?
We don't live there anymore. We moved out 6 months ago. 6, 7 months. No longer reside there.
That's even more concerning because that's the only address I have for the defendant.
The address that is associated with the other complaint, the new case, is on Riker Road.
Right, okay, I see that. So the Riker Road address is whose address?
That's where her family lives, Your Honor, her husband
Where?
and children. She was living there before this incident. Before the new incident, the 18th, the incident of the 18th.
Okay, so I get that on Riker Road. But then the alleged victim was there also?
That's her husband, Your Honor.
Okay, but he was there also? They were
Yes.
both living there?
Correct, Your Honor.
So where is this defendant is residing where now?
I'm staying
She's-
in a hotel.
She's after the incident with the no contact order in place, Your Honor, she left from the home and she hasn't been there since her arraignment on the 18th. And again, the January.
So, and the alleged victim, her husband, is at the Riker Road address?
That is correct, Your Honor.
So who the
I think that's.
Are you?
I'm sorry. Sorry, Your Honor.
Oh, no.
It's okay.
You don't just leap up and start yelling. I don't care who you are.
Well, I was just.
Seriously?
This is a critical courtroom moment that tells you everything about Judge Simpson's priorities: order, control, and respect for process. The judge isn't reacting to the content of what someone might want to say. He's reacting to the method. In court, the how matters almost as much as the what. If people can pop up, speak out of turn, or escalate emotionally, the hearing stops being a legal proceeding and becomes a chaotic argument. Judge Simpson's intervention also signals something deeper. This case already has heightened risk factors: 2 domestic violence matters, shifting addresses, and bond compliance questions. When emotions spike in the courtroom itself, it reinforces the judge's concern that boundaries are not being respected outside the courtroom either. The tone here is corrective, not theatrical. He's cutting the behavior off immediately so the record stays clean and the hearing stays focused. Judges do this to prevent intimidation, prevent disruption, and prevent people from manipulating the process with emotion. And from a legal standpoint, this matters because bond conditions and safety measures often hinge on the court's perception of volatility and compliance. This outburst, whatever its cause, lands right in the middle of a conversation about GPS tethering and no contact rules. That timing is not helpful for the defense.
Guess that's taken care of. Okay, so I guess my concern is that I do have the second one coming around, and they're located initially at the same address, but now not at the same address, but her address is temporary.
Correct.
And then I'm going to home of New Vision. yeah.
Correct. That was the
What?
next thing. She is slated to enter home of New Vision on December the 3rd, Your Honor.
Got it.
So that's where.
And that other.
Yes, so she's already gone through the admission, and the date that they have available for her is the 3rd. So she moves in on the 3rd from, yes, the hotel she's currently staying in now.
Okay. So here's what I'm gonna do. I am gonna order a GPS. I'll order it with exclusion.
If before the court does that, Your Honor, I do apologize. You did say it was going to be a long day. I apologize, and here I am.
Go ahead.
I know that the complaining witness is here today. My understanding is that there was going to be a request from us that there be a no non-consensual contact order in place. I know that the people have their own position on that. The complaining witness is her husband. They have children in common. They've been married for quite some time now. There were some issues at bay that may have led to these particular situations. Ms. Shear is working on that, hence the hospitalization, the treatment that she received there, and now her admission or self-admission into home of New Vision. She's very.
I can stop you. I'm gonna deny that request. I want to see how she's doing once you get in, how she's doing, because obviously there are.
This is where Judge Simpson makes a decision that's both firm and structured. He imposes a GPS tether with an exclusion zone, but he refuses to add an extra layer of restrictions on communication, at least for now. That combination reveals the judge's balancing act. GPS is about location control and enforcement. It's measurable. It's trackable. It reduces the risk of physical proximity to the alleged victim. But when it comes to a non-consensual contact order, the judge slows down. Why? Because the situation is complicated. The complaining witness is her husband. They share children, and the defense is presenting peripheral issues like mental health treatment and upcoming admission into home of New Vision. Judge Simpson isn't saying contact is fine. He's saying he wants to see stability first before locking in more restrictive terms. That's a judicial approach focused on monitoring progress and avoiding blanket restrictions that might create practical chaos, especially in family situations.
I'll just call them peripheral issues.
Okay.
So before I would let that happen, it's not to punish you or anything like that. Before I allow it to happen, I want to see where she gets in terms of that process.
Okay.
Okay, fair
Okay.
enough?
Yes, Your Honor.
I didn't care about you. I was talking to you. Oh, yeah, I wait for Mr. Nazi to All right, so what I am gonna do though is I am gonna order a GPS tether with the exclusion zone being the Riker Road
So I will.
location tracking. Pardon?
So, okay. Okay.
She just wanted clarification that the GPS would prevent her from being able to go to Riker Road.
Right, and also we will have location tracking because she's gonna be going into
And treatment.
treatment.
Sure thing.
I have a question. Is it okay if I go a couple hours away? Because I was planning on visiting my family.
You're going to be in the Michigan though, right?
Yes.
State? Yeah.
Okay.
She just wanted to know, she's traveling to visit her family, but it will still be within the state of Michigan. She just wanted to know if that was okay.
Oh, that's fine. That's fine. Okay. All right. Thank you.
Thank you, Your Honor. Okay. Should she go to community corrections now?
Yes, because I will be signing the order momentarily. We'll be good to go.
All right.
Okay. Yeah, so ma'am, how'd you get here?
I got a ride.
Yeah, you did. Who'd you get a ride from? Come on back up to the podium.
I got a ride from Kayla Miller.
Yeah. That's a
Because I
problem.
was told he was allowed to be here today.
Pardon?
I was told he was allowed to be here today.
This is the bond violation moment that turns the hearing into an immediate threat to her freedom. From the judge's perspective, it doesn't matter if she didn't realize at first. Bond conditions are orders, not suggestions. And when a no-contact order exists, getting a ride from someone connected to the prohibited party can be viewed as indirect contact or a clear boundary breach, depending on the terms. What makes this worse is the reasoning. I was told by his family. That's exactly the kind of informal advice that courts hate, because it bypasses the one safe channel, your attorney. Judge Simpson's reaction is measured but unmistakably serious. He doesn't cuff her immediately, but he pauses the matter and makes something crystal clear. You need a plan right now, and if the plan isn't good, custody is on the table.
And
By
I have
who?
another way here
Who were you told that by?
by his family. I'm in contact with his aunt. Huh? Yes. I have no form of transportation.
This is a problem. Because she's violated the,
I didn't realize I was violating it.
let me do this. I'm gonna pass the matter briefly. I'm not gonna take her in right at this moment. Counsel, I'm gonna allow you to explain to her the conditions of her release. And she's gonna have to find what hotel are you in?
I'm in a Celine Hotel, the Hampton Inn.
Okay,
It's right down the street from my job. So I can.
gotcha.
job.
So I understand that, but she's gonna have to figure out something else. So I'm gonna allow you to sit and talk with her, but somehow or another, you're gonna have to come up with a plan. If I'm not satisfied with that plan as to that, and there are people telling her things that are against her order, I'm gonna have no option but to lock her up.
I understand.
But I'm gonna give you a chance to talk to her about it.
Thank you, Your Honor.
Thank you. I'll pass it. Court recalls the case People versus Patsy Shear.
Morgan Poisson, people.
And Assistant Public Defender, we have Ms. Patsy Shear, who is approaching. Ms. Shear, could you state your name for the record again? Shear.
All right.
Your Honor, thank you very much for the opportunity to speak with my client. I have explained to Ms. Shear the situation that we're in and obviously the court's concern. Ms. Shear indicated to me that when I had originally spoken with her, there was an aunt of the family who was speaking with me on her behalf. She was also on the three-way. She explained to me that this aunt is actually the aunt of her husband, who she's known for over 15 plus years and plays the role of an aunt for her as well. So the information that she had received was from this aunt, and she was under the impression that since he was to be coming to court, that him bringing her to court was not necessarily a violation. I completely understand how that looks. And the fact that it doesn't, I think for those of us who are very familiar with the criminal justice system, it makes no sense to us, but she does not have a significant history or much contact with the court system or the criminal justice system. I would like to talk about moving forward what our plan is, though.
This is a strong mitigation argument from the defense. Mistake, not defiance. The attorney is carefully building a narrative that the defendant didn't knowingly disrespect the court. She relied on an aunt figure who was tied to the husband's side, and she lacks experience with the criminal justice system. Courts do take that into account sometimes, especially when the violation is not paired with intimidation, threats, or repeated behavior. But here's the problem. Ignorance does not erase risk. Judge Simpson can acknowledge that the conduct might not have been intentional while still concluding that she's not reliable without structured supervision. That's the paradox of bond enforcement. The court has to protect the complainant and maintain order even if the defendant's mental state, confusion, or inexperience contributed to the mistake. The defense also introduces stabilizing facts. Confirmed hotel stay, employment at Wendy's, proof of room key, a plan to use Uber, and upcoming entry into Home of New Vision on December 3rd for a 4 to 6 week program. These details matter because courts want structure. Where do you live? How do you get places? What's your plan? Those aren't casual questions. They're compliance questions.
Go ahead.
She is very apologetic to the court. There was no blatant disregard for the court's orders. She indicated that she is currently staying at the Hampton/Hilton Inn in Saline. She works at the Wendy's in Saline full time, and she says that that's the best hotel for her because she can walk right to work. She has been there. I asked her for proof. She has her room key. She said she checked in on the 19th when she was released from custody during the time of her arraignment. She has been working there as indicated as well. Her plan, she also asked the court about permission to go to Grand Rapids because her entire family lives in Grand Rapids. She has no family here in Washtenaw County or the Detroit area. So she would be going to Grand Rapids to stay with her family for the holidays. She would be there until Saturday. She's coming back and she would be going to Hampton/Hilton from that Sunday or Saturday, whenever she gets back, until Wednesday when she's able to get into Home of New Vision. She said she tried to get it to where she could go straight from Grand Rapids to Home of New Vision. They did not have any availability until the date for the 3rd. So she plans to be there. They've informed her it's a 4 to 6 week program. Her plan is to stay there the entire 6 weeks. I don't want to go into too much detail about what had happened at the time of this particular offense, but there were some significant mental health issues that were at bay. The report indicated that she had been the one calling the police because of a particular state of psychosis that she was in at that time. She has been working with CMH. She's been getting mental health treatment. They've advised her that we needed to do substance abuse treatment, which is what she's doing right now. What we're asking, I know traditionally in this situation, the court does not take lightly a violation of a bond order. And we're asking that the court allow her, she has a way to get home today. She has the Uber app pulled up on her phone. I've told her that I will show her exactly how it works. She's never done it before, but she'll be able to get the Uber to take her back to the hotel. She's supposed to work this evening at 5, and she would be working tomorrow and then hopefully leaving for Grand Rapids after work tomorrow.
Anything from the people? All right. So let me ask you this, ma'am. You're a CMH consumer client, right?
Yes,
Is your husband also?
not to my knowledge.
Did not. Subject tracking. Got it. All right. So I think the thing that I'm worried about is you kind of being, and I will indicate you should not have been or having that type of contact with him. You understand that?
I understand that now, sir.
All right. I don't see it as something that she intentionally tried to do because it certainly wouldn't have been to her benefit to do that, I don't think. I will order an exclusion zone. I'm going to order the exclusion zone tether. All right, that will also track you. You
Okay.
understand that?
Yes.
So we'll know where you are. And I think I'll just leave it at that at this point. Okay.
Thank you, Your Honor.
Give you a bit of a break, but don't let that kind of thing happen again. And the way that you deal with that, young lady, is that if somebody tells you you can do something that seems contrary to your bond, call your attorneys.
Okay.
This is the judge drawing the line in a way that's both compassionate and firm. Judge Simpson is essentially saying, I'm not treating this as intentional sabotage, but it ends here. That phrase, I'll give you a bit of a break, is not a reward. It's conditional mercy. It comes with two requirements: tighter monitoring and smarter decision-making. The exclusion zone tether is the court's enforcement mechanism. It's also the court's way of preventing accidental violations from becoming dangerous ones. With location tracking, the judge doesn't have to rely on stories, assumptions, or conflicting accounts. If she approaches the restricted area, the system knows. That's how courts reduce ambiguity. And the call your attorney's instruction is one of the most important life lessons a defendant can receive. Courts don't want defendants improvising. They want a single source of truth: legal counsel. When you're on bond, you do not outsource your decision-making to family members, friends, or someone told me. Because when it goes wrong, you are the one standing in front of the judge, not the person who gave you bad advice.
Okay.
Okay.
And ask them what you should do. Okay.
Yes, sir.
All right.
Thank you so much.
Anything else? You're welcome. Bond will continue with that one adjustment of the GPS.
Thank you, Judge. Thank you.
Thank you. Okay. Yeah.
Here's what this hearing ultimately shows in plain terms. This case isn't being shaped only by allegations. It's being shaped by compliance, risk, and credibility. Judge Simpson, male, was dealing with a defendant tied to two domestic violence matters involving the same alleged victim, uncertain housing details, and a bond compliance scare that could have easily ended in immediate custody. The judge's approach was structured. He pushed the attorneys to stop muddying discovery issues, he forced clarity on what materials were actually provided, and he refused to let disagreement stall the process. On bond and safety, the court made a clear call. GPS tethering with an exclusion zone was necessary because the risk profile increased and the defendant's decision-making, whether intentional or confused, created uncertainty the court couldn't ignore. At the same time, Judge Simpson didn't pile on every restriction possible. He denied an additional contact-related request for the moment, emphasizing he wanted to see progress in treatment and stability before tightening further. That's the court balancing protection with practicality, especially when children and a spouse are involved.